There are certain allegations against us, my lord. Kindly.
Allegations, DI against allegations are all proper.
Your lordship has not gone into the merits.
I have gone into the merits.
Grateful. Grateful. I led by Miss Juma Chakraborty.
Where is she?
I was told that she was online.
I do not see. Nobody is there. Can you see? Nobody is there. It's only Gaurav Das. Nobody else.
Before appellate side, may I forget to mention one ASEAN matter because of that one. My lord, already in Subhish Sarkar matter gave the age relaxation to the candidate of 2016, my lord. Here, my lord, the petitioner, two petitioners, my lord, two separate. The gave the age relaxation of 2016, not specifically tainted. They are not specifically their name not featured in any of the list. They not got appointment. Any of the list, then
Which class?
class 9, 10,
11,
and 11, 12.
9, 10, 11.
11, 12, my lord, urgency regarding my lord, 11, 12 is that, my lord. At the time of verification,
It was detected.
detected and rejected. So that's the reason, my lord, and the interview is going on, my lord. It will be kind enough, my lord. If my lord get left tomorrow, anytime, it will not take more than 5 minutes. Already, my lord's order is there, my lord, regarding groups.
All right, tomorrow serve notice upon the commission. Affirmed?
No, not, my lord. Until
Get it affirmed and then give.
okay.
ঠিক আছে, এক্ষুনি করে দিস।
Repeat those. Item number 1 from the
কোথায়?
Correction. What is the correction?
order is okay. Name of the state advocate.
All right. These names have gone down wrongly. The names that are appearing are wrong.
Wrong. Both things.
For the state wrong.
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 These two will go out and these two will come in. Right. Give your names, please.
I'm giving. This should. I'm ready.
Three. 3 minutes I am for the statement. Relaxation of SLST 2025. Petitioner before your lordships, my lord, not specifically tainted candidates. My lord, at the time of verification, my lord, only on the ground of age relaxation, his candidature has been rejected. Start from the petitioner subject on and from my lord 15. That's why, my lord, I have, my lord, annexed the rejection order. That is at page, my lord, 35.
But in this case, there is a mistake on our part, I must say. You know, in this case, there is a mistake on our part. But he will be allowed, and he has been asked to appear in the interview on 16th, and he should be, he should generate the intimation letter. There's a mistake on our part.
Will you forward a general intimation or notice to the petitioner? Otherwise, how will he get to know?
He can download from the portal itself.
It is there in the portal?
Yes, already we have placed it.
Uploaded.
That is his submission.
Uploaded.
No, initially we have rejected. That's correct. But that rejection was not correct from our part.
Right. So how will the petitioner get to know that the rejection was a mistake?
No, we are allowing him to appear in the interview.
Then I'll record your submission.
Yes.
Please come. The petitioner was a candidate in the first SLST, 2016.
But he is an untainted appointee. He was there.
All right. She participated in the second SLST 2025 and claims to be an untainted appointee of the 2016 recruitment process. Stop. Her candidature has been rejected on account of overage. She is aggrieved by the same. Stop. Learned senior counsel representing the commission submits upon instruction that the rejection was erroneous. Stop. The commission will rectify the mistake and permit the petitioner to appear in the interview and the credential verification.
Credential verifications have already been done.
Verification done.
তাহলে verification টা
She will only appear on 16. Kindly record
only
that.
interview.
Only interview.
All right.
And for the petitioner subject below, interview date has been fixed on and from 15th.
Yes, your date is 16th.
My date is 16th. Below, kindly.
And she has been and she is scheduled to appear in the interview on 16th December 2025. Step. In view of the submission of the commission that the rejection of the petitioner's candidature was erroneous, erroneous, and the commission will permit the petitioner to appear in the interview. Accordingly, no useful purpose will be served by keeping the writ petition pending. Stop. The same stance disposed of.
Subject to Lord's correction, kindly direct the SSC to upload the admit card for appearance in the interview. Otherwise, I will not be in by this time. If not,
We have already uploaded. We have already
if not
uploaded.
uploaded, if not
We have
uploaded,
already uploaded the intimation letter. You can find it out. If you have any difficulties,
The
please contact
intimation
me.
letter and the admit card of the petitioner for appearing in the interview shall be uploaded in the portal of
Only intimation, not admit card.
Admit card is not there.
Sorry, intimation.
intimation.
Only
At the
intimation.
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 No admit card.
Admit card is there. I am sorry. Stand correct.
Intimation will be uploaded in the official website of the commission if not already done.
Grateful.
Right. Develop list.
Item number 4.
Yes, okay.
Item 4, my lord, for the petitioner, my lord. The petitioner recently applied for in the second SLST as an EWS candidate.
Second
Yes,
SLST.
Yes, madam. EWS candidate, my lord, can you see her form? Application form.
Yes, EWS.
The written as EWS, my lord. Also, you got it, my lord?
Yes.
Now, my lord, she appeared in the verification. During verification, she was converted from EWS to general. The ground is, my lord, she obtained EWS certificate after a cut-off date, according to the. But according to the School Service Commission, the cut-off date was 21st of July. But according to, my lord, kindly see their notification, my lord. Subsequently, pursuant to the direction of the Supreme Court, they also reopened the window for making application or correction. Well, can you see the notification version of the notification? In compliance, may I read, madam? In compliance with the solemn order dated such and such, it is hereby notified that the West Bengal Central School Service Commission shall provide a window for 10 days for receiving application. Next, the candidates, next paragraph, the candidates who have already applied and have received admit card need not apply again. So till that date, the portal was open. Even one who did not apply in the previous occasion, they also can apply of that date in terms of this notification. So on 21st July is not the last date. 2nd September was the last date according to this notification. Before that, I obtained my EWS certificate. I obtained my EWS certificate on 12th August.
What has this got to do with the EWS? I cannot follow.
Well, they have rejected my candidature as EWS candidate only on the ground.
That you obtained it later on.
I obtained EWS
So where is
certificate on.
the error?
Yes, madam.
Where is the error?
they fixed the cutoff date 21st July because
They did not fix. The application date was such that it ended on the 21st of July. The advertisement, the recruitment notice says so.
yes, the recruitment notice said 21st July was the last date for making
Right.
application. That's why
Yes.
that is the cutoff date. But that not the last date of my, according to my submission, according to this notification, 21st July is not the last date of making application. But 2nd September was the last date of making application. Can you see this notification?
I am not with you.
Well, this notification says so, Malad. Kindly see.
I read the notification in a different way. Please come. The petitioner participated in the second SLST 2025 as EWS candidate. Stop. She has been treated as a general candidate by the commission as she relied upon the certificate under the EWS category, which was obtained after the last date of receiving the applications. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that though the last date of filing the application was initially 21st July 2025, but later on the commission provided a window of 10 days for receiving applications by notice dated 22nd August 2025. And accordingly, the last date for filing the application stood extended till 2nd September 2025. Stop. The petitioner obtained the EWS certificate
12th August.
on 12th August 2025. Stop. It has been submitted that the petitioner ought to be treated as EWS candidate. Stop. Paragraph. The recruitment notice published by the commission on 30th May 2025 clearly mentioned the last date of filing the application, which was 14th of July 2025, later extended till 21st July 2025. The recruitment notice clearly mentioned that that for seeking reservation, certificates issued prior to the last date of filing the application shall be considered. Stop. Paragraph. The petitioner applied within the said date, but she received the EWS certificate later on, that is on 12th of August 2025. Stop. The window which the petitioner is relying upon in terms of the notice of the commission dated 22nd August 2025 was only meant for the candidates from these selected and appointed untainted candidates who were permitted to continue in service till 31st December 2025. Stop. The petitioner cannot avail the benefit of the said window provided by the commission, as she already submitted her application within the due date. Stop. paragraph. If relief is provided to the if the benefit of reservation is provided to the petitioner, then there may be several other candidates who obtained their EWS certificate beyond the cutoff date, who would be deprived the chance to be treated in the reserved category. Stop. The same will injustice to them. Stop. Next. In view of the above, the relief prayed for by the petition fails and is hereby dismissed.
Item number 5, sir.
Yes.
But in this matter, I need 7 days time to bring the review chart. That's an evaluation matter.
I am appearing for the petitioner. This is my affidavit of service.
Yes. What is your prayer?
My lord, at the initial
Microphone, please. Use the
at
microphone.
the initial stage, petitioner was the organizer teacher.
Organizer teacher.
The school was recognized in the on
No. Huh?
1st May 2000, and thereafter, my lord, the service of the petitioner was approved on 1st May 2000. The petitioner has served the school authorities 9 years, 9 months. After completion of the 9 years, 9 months service,
But sorry, it is not our matter. Sorry.
my lord, he prayed for pensions according to the death cum
There is
retirement
shortfall,
benefits.
you want regularization?
Yes, shortfall. My lord, similar circumstances, my lord, same teacher has got, my lord, the pension. Kindly see the order.
Same
passed by
teacher got pension means?
Similar circumstances,
Similar
a teacher who has completed 9 years, 9 months service, by the order of the, my lord, school department, my lord, is getting pension. And this order has been passed in compliance with the order passed in a writ petition. My lord, the Honorable Division Bench also passed the order to comply the, my lord, circular passed by the School Education on 2nd September 2009, where the shortfall of the, my lord, service of the petitioner should be considered in accordance with law, and in accordance with the rules of finance department, he is entitled to get minimum pension. This has not been considered, my lord, in this petitioner's case, and the petitioner's, my lord, application has not been considered by the school department.
Give me that notification of the state, the government order.
Kindly see, that is at page 34. Page 35 of the writ petition.
Page 34 is so illegible.
Page 35, next page, page 35, typed copy.
All right.
And my lord, this notification is dealt with by the Honorable Division Bench.
Please come. Did you approach the authority?
Yes, my lord.
You have any
My lord, yes, the
instruction?
instruction, my lord, the 3 months delay may be condoned, my lord.
The petitioner, please come. Retired from service on 31st January 2010. After rendering total service of 9 years and 9 months. Stop. There is shortfall of 3 months to complete 10 years of service for entitlement of pension. Stop. Reliance has been placed on the memorandum of the School Education Department, being number 26, page 35, please copy. Dated 2nd February 2009, which mentions that a fraction of a year equal to 3 months and above shall be treated as completed 6 monthly period of service. And reckoned as qualifying service for determining retirement benefits. And the period of service below 3 months will be ignored. Stop. The petitioner prays that he will be covered by the aforesaid memorandum and the terminal benefits of the petitioner be disbursed. Stop. Next. Learned advocate representing the state respondents has obtained instruction from the Assistant Secretary, School Education Department, dated 5th of March 2025, wherein the authority has opined that in the facts and circumstances of the instant case, the shortfall of 3 months period of the petitioner may be condoned as per the existing rules. Paragraph. In view of the above, the instant writ petition stands disposed of by directing the pension sanctioning authority to take necessary steps to condone the 3 months shortfall of the qualifying service period of the petitioner and take necessary consequential steps for releasing the terminal dues of the petitioner. Stop. Next. The authority shall now, as the petitioner retired from service in January 2010, accordingly, the authority shall take urgent necessary steps in the matter and ensure that the petitioner receives all his terminal dues at the earliest, but positively by 31st of March 2026. Disposed, this will be written with the records. Affidavit of service be written with the records.
Father, the benefit should be given with interest.
With interest, did you raise any prayer earlier? Why did you come to court at such delayed point of time?
No, my lord. 3 writ petitions were moved by the writ petitioners.
3 writ petitions and you did not get the relief.
No.
Why?
My lord, School Education passed the order. Kindly see that order. The order that so far as
Shubhradeo, as the dues will be received by the petitioner long after his retirement. Accordingly, the same shall be paid along with simple
There
interest.
is such prayer for interest here, my lord.
Simple interest calculated at the rate of 5% per annum on and from the due date till the date of actual payment. This is absolutely illegible.
Item number 6. My lord, 6, my lord.
I'm appearing for the SSC. But only thing, the review report we need to another 3-4 days. This is a review matter. Kindly keep it on Tuesday so that we can bring
Review
the
of
review.
what?
This petition, 43 petitioners are before your lordships, my lord. My lord, they are just shortfall of 1 or 2 marks. My lord, in the provisional answer key, my lord, the answer option was correct according to me, because we have chosen that answer option, so we did not raise any objection. My lord, in the final answer key, my lord, they have changed the answer option, my lord. The very common question, my lord, we have referred 5 references.
Whatever. So the council intends to revert with instructions.
My lord, only one prayer, my lord. Let there be a direction by your lordship to consider the averment made in the petition, supported by the ISBN numbered book and renowned professors as well as the international authorities in support of my contention at page 15. Starts from page 15.
Please come.
No, I beg to appear on the statement.
The how many court fees have you paid?
Yes, I have paid full court fees.
Please give. The petitioners participated in the second SLST.
Court fee.
80. Assistant teacher.
Assistant teacher for subject geography.
For subject geography. 25. The answers marked by the petitioner in the OMR tallied with the marks, tallied with the answers provided in the preliminary answer key. But the same got changed at the final stage.
And one prayer, my lord.
The petitioners are aggrieved by the same. Stop. They rely upon several study materials in support of the submission that the answers which they had given and the answer published in the preliminary answer key are correct. Stuff. Learned senior counsel representing the commission seeks time to revert with instruction. Stuff. Next. In view of such submission, released on 22nd. 22nd, will it be all right?
He has joined another court, I am told.
22nd.
Only one recording maybe. But in respect of 3 questions, they have awarded marks to all. In this subject,
I was only suggesting
What?
22nd minute perhaps may spill over till after vacation.
I do not know.
The 22nd, this
Okay.
bench is.
So what? 22nd. Next. After the receipt showing payment of deficit court fees, we retain with the records. Service is also taken on record.
well, next is similar subject, but with great elaboration, my lord. We have tried our best to present before.
Convinced that the answers are proper.
Yes, my lord. In each and every questions, my lord, we have added 4 to 5 references, all of the national level scholars.
I do not know. See.
Lord, let them consider with our the references and file a report before the lordship, my lord.
Only
Can be passed.
same order can only this much.
This is also
I will request Mr. Alamgir, instead of clubbing 39 petitioners in one, it becomes one petitioner, one series of questions. It becomes easier for us to respond. Kindly visualize,
I understand.
extremely difficult, and with this shortage of time to come up even with a report by 22nd is a Herculean task. I beseech you,
But then since
Unemployed youth, my lord.
Unemployment is not the factor. Thing is, since everything is now computerized,
Yes.
maybe not that much of a problem.
Correct. But at the same time, each case is not same. Each petitioner does not have the same problem.
I have followed
39 petitioners has 39 problems. Maybe subject is common.
the questions. Will
Question it may. I am not saying it is.
Also common. The problem is also common. They will
question.
Yes, they will respond to the question and answer only. They will not respond to each of the petitioners.
No, that is proper. How many questions defective? 3?
12.
12?
Yes, my lord. Kindly, I can place before your lordship all the questions. I can place before your lordship all the questions.
Then he says the preliminary answer key is all right. Then what type of professors are there?
Well, Your Lordship, kindly consider.
So that not,
amendments.
as Mr. Bandyopadhyay submitted before your lordship on the other day.
Item 8.
So your lordship is keeping it on 22nd.
Well, payment of deficit court fees and
7 will be same as 6.
I'm deeply obliged. I'm deeply obliged. আটে কি বলছেন ওদের?
Mr. Nag, just check up WPA 26316 of 2025. This has been disposed of. There is some problem with the recording of appearances. It was mentioned. Commission's appearance has been recorded, but now the state's appearance got changed. I do not know. Just inquire. I can see the name of Mr. Shish. Yes.
Well, we had mentioned, Milord, it was on our instance.
Right.
Our appearances were not there.
Right. And in the corrected order, it has come up Mr. Shishonna Bandyopadhyay, Shondip Dasgupta, Sakib Siddiqui, and Niket Ojha for the state. Are they appearing for the state? Because in the earlier, the other date, they were not there. Some other names are recorded as state councils. Was it wrongly recorded?
I will be candid, Milord, to assess the situation. What has happened is, Milord, as these SLST matters are a bit sensitive and the government is looking after it in a very sensitive matter, Milord, a bunch of advocates have been engaged directly by the department to assist the court.
So,
So at times,
for state,
overlapping appearance.
no issues?
There is no. There are authorities. They are appearing on authority of the department, Milord. I know it for a fact.
No, it is not there appearing. Previously, 2 other names were there. Will those names remain?
They are the GP engagement, Milord, but that is not a difficulty.
That will remain.
No, that will remain. That will remain.
This is happening in these matters. There are overlaps at times.
I do not have any problem. I was wondering whether again it will come up for correction.
No, it will not. It will.
This is the reason. Otherwise, how does the court have a problem as to who appears?
But there is no.
No issues. All right. Then this will go down.
6 questions.
Because
6 questions. 2 questions.
6 questions. Answers. Answer. Wrong. ছখানা question বলছে Six না 4 কত 4টে question. এই দেশে
yes, 8.
My petition for the state.
What is it?
4 question that have challenged that in the subject English. If it was straightway comes to that page 37, that
Preliminary answer key is all right.
no, I have made objection in respect
In
of 1.
preliminary answer key stage.
Yes, in respect of 1.
All right.
And so far other is concerned, I have not.
You have not means the answers tallied with your answers,
Yes.
or you did not choose to.
Insofar
file any
2 question is
objection.
concerned, they have given full marks to all.
So you are covered by that?
No, I am challenging that
You are challenging that,
they
Okay.
cannot do this.
right?
And page 37, I have given suggestion,
কি দিল্লি থেকে লিখে পাঠাচ্ছে?
but they have given full marks to all. Yes, they have given full marks to all. To me, this one answer is perfect. So these are my challenge. But let them not file a report on this, because they have their experts. Then
But then the experts have already formed an opinion, and the
If they
final
have-
answer key has already been
they-
published.
no, I have maybe, but I have given some suggestion here along with the books
And so far the marks given to all, that also I have challenged, my lord. The commission has to take a stand, my lord. Then commission has to file a report. Well, the question is, my lord, university takes up 1 at page 37. Question is, change the following statement into a question.
Page 37.
Page 37, question number 43.
In the writ petition, what is this scan?
The scan is, my lord, for other interveners, my lord, claiming similar benefits.
Can have service which we don't have a can. Okay.
Other interveners claiming similar relief.
They stand. They stand in the same footing as that of the petitioners.
Same question.
How many court fees have been paid?
No, there are 3 petitioners here, 3 or 4.
No,
So far,
the application.
so far interveners are concerned.
It's a good way,
Avoiding, no.
avoiding.
No, avoiding. First only 3 came, and thereafter this
300 comes.
chunk came.
Now kindly see the size of the application and kindly see the.
I was wondering. That is the reason I was wondering.
49.
49.
37 page.
Page 37, lord. Question number 43.
43. Where is question 43?
Left hand side column.
Left hand side column. Yes, 43. 57 is mentioned. What is that? Marks to all.
Change the following statement into a question. The statement is, nothing could be done. Nothing could be done. Nothing. My answer is, what else could be done? Now, I'm going to kindly compare with the others. What should have been done? Can't be. What else could be? Could you do? Only one, singular. What have been done? So, there is no doubt.
I am not an expert in English.
But yes, then somebody.
No, what will be the correct answer? No way.
Some independent expert is not required.
They have their own expert.
But maybe, but I don't mind if the expert gives me the right opinion.
I just don't know.
But they are questions are being raised against that team led.
Okay. 33.
Here, from a poem, this question has been made. Whom does the speaker meet in When's poem, Strange Meeting?
Yes.
Now, page 33, right hand side, clause, question number 6. Now, kindly takes up, along with this, page 52.
No, what is the answer over here?
Correct answer should be enemy. Correct answer, I have made enemy. I have to find it from the poem.
According to the preliminary answer key, what is the answer?
Both.
Both means?
Friend and enemy.
How can both be friend and enemy?
English is a strange language, and that too a poem. That is why strange meeting.
Figures of speech.
Figures of speech. The curtains.
Yes.
I'm not page 52.
He said something very nice. Now,
page 52, Malat.
Yes.
I have taken this suggestion from this page.
Whatever. Please do not read.
Yes, but that's why a party is required to be appointed. I don't mind any independent expert is appointed.
You may not mind. Let the commission file a report later.
No, here we have a thing to say. Not all of the petitioners apparently or the applicants did not challenge 12 questions.
Same question they did not challenge. All different.
Then there is no homogeneity according to us. Objection has not been raised by all. That is also on instructions I am submitting, and it is again I repeat, Herculean for us to respond to 49.
How many questions have they in total objected to?
4.
4. Which are the questions?
In this petition, 4.
Which are petition and the application together?
4.
Which are the questions?
Page 33 I have shown to your lordships.
Each petitioner একই question. 49 times.
Yes. Only 4 questions. There may be so many candidates, but their grievance is the same. Yes?
2, 6, 15 and 43.
But then the answer series booklet and everything will be different, isn't it? Page number
I
say?
have
Page number 33.
33, 34
33, 34.
and 37.
There are no preliminary objections from everyone.
Even if it is there from one, the answer will be the same.
Your lordship will, in that event, instead of 49 persons and everything, we'll file a report only pertaining to the questions.
Questions,
Yes.
not to the candidates.
I don't differ.
33, question number 6 at the top, right?
6.
And 34, question number?
Now, question at page 33, question number 2 and 6.
Question number 2, the new teacher.
New teacher.
All right.
2,
Question
6,
2 and 6, 34.
15,
34, question number 15.
and 37, question number 36. Sorry, 37, question number 46.
43.
43, yes.
That's the number.
Question number 43.
43, yes.
Kindly indicate in your lordship.
Yes, it'll be easy for you all. Please come.
Report
The
to
petitioners
1000.
and the applicants participated in the recruitment process of second SLST within bracket 80, 2025. Stop. They raise objection with regard to the answer published in the final answer key in respect of certain questions. Stop. It has been submitted that the answers provided by the expert committee, answers marked by the petitioners are proper and they rely upon several study materials in support of their submission. The particular questions objected to are question numbers 2 and 6 appearing at page 33, question number 15 appearing at page 34 and question number 43 appearing at page 37 of the writ petition. The commission is directed to revert with instruction, written instruction. 22nd.
22nd, Miller, all these together.
Nothing will happen.
Mr. Singh will be, let it be after the vacation.
What about the court fees? Have you?
So far, intervention is concerned, but I don't require.
That is the strategy.
Stand in the same footing as the petitioners and you do not require.
Well, let them file my report.
Listen, you choose. You can restrict it to the petitioners also. If the questions are the same, what is the use of pressing the can?
But if I want to file my court fees, I don't mind that. But if I want to file court fees, I have to refer a writ petition number and
the writ petition number is there.
Once it is allowed, then he can deposit. Once the intervention is allowed, he becomes writ petitioner. Then he cannot
pay the entire court fees if he is pressing the application.
Yes.
Well, I'm unemployed.
49 petitioners in the application and 4 in the writ petition.
I leave it.
Technicalities you have to follow. And if you can continue the writ petition with only the writ petitioners, original ones, choice is yours.
No, I shall.
What? You'll
I shall
fail.
pay.
Everybody wants to stay in the fray. Yes, I'm fighting.
Yes. Why take chances?
Ultimately, in game hall.
But only one thing may I be permitted to say, Miller.
Yes,
Just,
please.
Miller, if the preliminary objection have not been raised, your lordship has seen yesterday the cases. Something preliminary objection has been said. Something writ petition in some writ petition, some amendments is there. But in cases where the preliminary objections have not been made, that cases cannot be entertained at all.
Provided the answers differed in the very first stage, if the answer tallied at the preliminary answer stage, then there is no question of filing an objection.
Therefore, no. My lord, that cannot give him civil right. Right accrues only after the preliminary objections have been given.
No.
Your
if
lordship is
the
saying in the
answer
case where the
differs.
answer, I have understood. Understood. Your lordship is observing that if there is no wrong with the answer in the preliminary level, they have not given the objection.
Yes.
But if
Yes.
in the final
Yes.
level,
Yes. Right.
I have understood. I have understood your system.
The writ petition has been filed by 3 petitioners by depositing only 1 court fees. Thereafter, an application for being added as parties as petitioners in the writ petition has been filed by 49 applicants. As the applicants claim similar relief as that of the petitioners, accordingly, the applicants would be required to deposit the court fees. Accordingly, the advocate on record of the petitioner accordingly to deposit deficit court fees in respect of 49 applicants and 2 writ petitioners, that is 51 persons, by 19th December 2025.
No. That is only for the court.
Can is allowed.
Can allow for
the department will be required to make the necessary correction in the cause title of the writ petition by including the applicants as added petitioners in the writ petition. Yes.
22nd.
Even the petitioner does not.
Yes. 9.
My lord, I am for the petitioner. My lord, last occasion, your lordship directed me to file a supplementary affidavit annexing the date. My lord, I have intimated. My lord, there is also a delay. My lord, I want to put some medical documents also. If your lordship kindly file afresh with withdraw with the liberty with documents, because after 3 years it has required. After receiving the amount,
you want to withdraw this?
Withdraw with the liberty to file afresh with better document, my lord.
Please come. Learned advocate for the petitioner submits that. Have been missed out at the time of filing the writ petition. Prayer has been made to permit the petitioner to withdraw the same with liberty to file fresh petition upon proper and better particulars. Leave sought for is allowed. The instant writ petition stands dismissed as not fresh. It will be open for the petitioner to file fresh writ petition annexing proper and better particulars.
Great. Next is also same.
Then
Same order.
Same order. 9 give chill.
Item number 11.
Item number 11, I am for the petition, and on the last occasion, my lord directed me to pay the requisite court fees. My lord, I have paid this. Here is the receipt.
What is the matter about?
The matter is about, my lord, the petitioner had applied in second SSC examination under the category of SC and ST, and thereafter their caste have been wrongly updated into general one, my lord. And they have applied under SC/ST and paid the fees of 200 rupees, which is required for SC and ST. The application started, my lord, on page 25 to 74, my lord.
All right. What happened to that appeal?
I can take.
It will be taken up?
Taken up.
I'll post this matter tomorrow. All right.
Grateful, my lord.
Check up with the division bench. There is an appeal going on the same issue. Whatever the appeal court decides, we'll follow. Do one thing. You keep this and bring this tomorrow. Order.
Great, my lord.
Keep your blessing.
Item number 12.
It is that matter, my lord, where, my lord, the petitioner is in a army public school, my lord, private schools, my lord, have challenged the
Rules also.
one portion of the rules, that is, my lord, at secondary level in government or government aided, government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or on contractual basis. That is at page 45. This is the part under challenge in this matter. My lord, before going into this matter, my lord, I just humbly submit, my lord, there are other, 55, my lord, it is also the same. So far as this matter is concerned, this is a teacher of Central Board of Secondary Education.
Army Public School.
Army Public School. 55, my lord, is for the West Bengal Government School, private school. But in this regard, my lord, I would just humbly submit that the judgment of the division bench,
In the matter of?
my lord, that is passed recently, my lord, in Arunima Pal.
Yes, 16th July 2025.
Yes, my lord. 16 July 2025. Paragraph 34.
Yes.
Did you copy that?
I have a copy here.
Miss 34, my lord.
Yes.
But what is the object of this experience? This has been defined here. My rule was not challenged before the division bench. The awarding of 10 marks is an weightage to be given on the basis of experience, and it is only expected that in a selection process of this nature and kind, all candidates are required to undergo the rigorous of the selection process in order to select most suitable candidates. Proportionate wage based on the length of service to the extent of 10 marks to be given to such candidate is not arbitrary. The object is to select and appoint experienced teacher. My lord, this is the object. Now, my lord, I just do the rules once. My lord, your lordship knows, my lord, School Service Commission. My lord, they appoint for government aided and government sponsored school. They don't appoint even for government schools also. So, my lord, here it says at secondary level in a government aided or government sponsored school. Well, I am on the term school. But NCT Act. School. Now, my lord, kindly come at the top in the definition clause of the rule, that is 2Z. 2Z.
Yes.
The words and expressions not defined in these rules, but defined in the Act or in the National Council for Teacher Education Act 1993 shall have the meaning respectively assigned to them in those acts. So, my lord, according to me, subject to correction, the meaning of the word school shall be taken from the National Council for Teacher Education Act. NCT Act. My lord, as per the definition of the school, my lord, I am just bringing the act, my lord, it's my fault. It has 3 parts. One is the government school, one is government aided school, and, my lord,
Sponsored school.
unaided school.
Unaided school.
As per the 1993 Act. But I shall place, my lord, there are 3 parts. So the 1993 Act says there are 3 types of schools, out of which, my lord, 2 types of schools have been included in the rules. So, my lord, there is a class among a subclass. Because 1993 Act, 1993 Act, NCTE Act, that is a central act for the entire country, my lord. There, my lord, so far as the definition of the school is concerned, but it says that there are 3 types of schools. It has been defined. My lord, I'll just place just a few minutes. In this regard, my lord, I have searched, my lord, about the judgments with regard to the Honorable Supreme Court and other high courts. There is no point in this regard till now that whether private school teachers can enjoy experience in this regard. But there is one judgment, my lord, recently passed by the Supreme Court at about 2024 SSC Online SC 53540. There, my lord, rule was not under challenge, or the advertisement was not under challenge. কোথায় গেল? NCT একটা আনাও, তুমি কি করলে? My lord, here one person, my lord, paragraph 6.
First, tell me whether you are there in a substantive post.
My lord, substantive, I'll come, my lord. Substantive, my lord, this entire rule, this part is under challenge. Substantive means it is approved. It is not a permanent post. It is approved. It does not mean that it is a sanction by any authority. Well, I'll come to the...
Approved by which authority?
Well, if it is a private school, it has to be approved by the managing committee. The post cannot be approved by the government. The post cannot be approved by the government. What is substantive, my lord? I have got one judgment of the Supreme Court. It clearly says, my lord, I'll come to that. But my contention is, whichever post or whatever may be, the experience must be counted from a recognized school. Because the private schools, my lord, are recognized by the state of West Bengal. No objection is been given. So their standard of education, my lord, is recognized by the state. Maybe the private school is not functioning properly. Standard of education is recognized by the state. My lord, just kindly come to this one. 2024 SCC Online SC 3540.
This was placed on the last occasion, Monica.
No, my lord.
Chaudhary Charan Singh.
Chaudhary Charan Singh, yes, my lord.
Yes, right. This was pointed out.
My lord, just one paragraph, my lord, just I want to show, that is at page, paragraph 22.
Paragraph 6 you said just now.
Paragraph 6, my lord, your lordship, the paragraph 6, what was
I
the
distinguish
contention of
this
the...
judgment from 6 Roman 4 and paragraph 26.
My lord, kindly...
6 Roman 4 kindly sees the fact he was given, HOD had given him certificate.
Yes, that was I was showing, my lord, HOD has given him the certificate, but the HOD was not authorized to give him the certificate. He was working under private, and my lord, he was under the university concerned. He was working there, but the HOD was not authorized to give him the certificate. In that event, my lord, Supreme Court stated, but the very important point, my lord, paragraph 22 from the 1, 2, 3, 4, 5, 6, 7, 7th line from the bottom. To our mind, the primary concern is the nature of work performed and whether the work undertaken by the candidate has any nexus with the purported work to be undertaken during the course of regular service. So, my lord, the nature of work which I perform, be it in private school, be it in any other school, whether it will help in the regular service or not, that is the test, my lord, the Supreme Court applied. And my lord, my learned friend was harping on paragraph number 26. Paragraph number 26, I will also place paragraph number 27.
25746. उसमें same point है. 25746.
The true thrust of every selection process ought to be find out and select suitable candidates. Well, the object what the division men stated. having experience in the related work and fulfilling other criteria from among eligible candidate, and to go ahead with appointing the more meritorious of those found suitable. If in need an individual without having any security of service performs up to the mark and receives commendation from none other than the head of the department, who must have closely watched his or her performance, it would occasion a failure of justice to exclude such individual for no better reason than she did not work on a sanctioned post. My lord, here the head of the department, my lord, I can show, that's why I was referring to paragraph number 6, the submissions of the university. He was not entitled even to give that certificate. The government order was there. My lord, thereafter, my lord, my learned friend would say, in need, if such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity, so as not to generate false hope in the minds of individual aspiring for the public employment. My lord, here I say, my lord, the rule or the advertisement was not under challenge. But my lord, paragraph 27, your lordship may see, an underlined current throughout the constitution is the theme of social justice. The preamble as well as Article 38 of the Constitution enjoins upon the state instrumentalists the duty to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life and endeavor to eliminate inequalities in status, facilities, and opportunities. So, my lord, social justice is also been taken into consideration while passing this order. And my lord, advertisement was not under challenge. What was going on in the court's mind was the nature of job which can help the institution or a regular service in future. This much, what I want to place. And my lord, I would substantive, my lord, I will place what is substantive post that has been defined by the Supreme Court. 1980, volume 4, SSC 226. Really?
This was also placed on that day. This was probably also placed by Mr. Ahmed that day.
Not in this matter, in some other matter?
Some other matter. But without interrupting my learned friend, those matters are kept on 22nd December. I'm only apprising your lordship so that we don't argue the same point in a piecemeal manner in other matters. I'm apprising my learned friend that it may be taken up with those matters. I can give the WP numbers. We have it.
This is same private school.
Same thing. And also, my lord, here he has to overcome page 22 also is fragmented service. And ad hoc and fragmented, both are there. He has to overcome that.
In the rules even.
That also he has to overcome.
That is not there in the rules even.
That is the most important part, Miller, in this matter. Leave aside the rule, Miller, whether allow private teachers or not. Can you see the page 22?
Your service period, see page 22.
Yes, my lord. Yes, my lord, I admit, my lord, my service period is a continuous service.
In none of these stages, you have completed one complete year.
But actually, renewal in Parmi Public School is made in this way only.
Whatever. I do not say that what you have submitted is improper, but whether this will entitle you to get.
My argument, so far as this matter is concerned, my lord, there are other matters where
yes, maybe have better points.
No, but so far as this point is concerned, my lord, what matters is the experience. Admittedly, my lord, I have worked from 3rd April 2019 to 31st March 2020. So
not even a year.
Not even a year, but My lord,
Only this much
I
of
gained.
experience and they are giving 2 marks for one completed year.
So from April to March 2020, 2019 April
So
to
they'll catch up from here 2 months, from here 6 months, then 8 months, and then all add up to make 1 year. How will they calculate this 1 year?
My lord, total year will be calculated from A to D. A to
And
D.
what about the months? where
That
you
will, my lord, not be taken into consideration.
can this be done? One complete year, you get 2 marks. There is nothing to show that you have got.
My lord, one completed
year
3rd
of
April
service.
2019 to 31st March 2020. 3rd April, if it is 1st April, my lord, it will be 1 year.
Not only.
3rd April 2019 to 31st March 2020. Then, my lord, 21st August 2021 to 31st March 2022. 2 days short. So it is around, my lord, October to March, it will be 6 months.
Then
Then
when
9th
you
May.
get this 1 year, how do they calculate this 1 year?
My lord, the first A is 1 year.
No, it won't be.
B is 6 months.
A will not be 1 year.
31st
Part of
April 2019 to 31st March 2020.
April.
3rd April. So
13th April.
3 days short. 3 days short.
Then what can be done? Where do you get? There may be matters where the teachers are there for years together. In that case, we will see. But is this a good case where you can get the
The
benefit?
rule does not say so. The rule says it will be calculated per year 0.2.
Where is that year?
My lord, to calculating from A to D, my lord, it comes a year.
No.
And also, my lord, if they are aggrieved by the rules and the interplay of the rules, they could have come earlier also. The rules were there.
Challenge. It has been submitted that the rules is under challenge.
It could have been done, my lord, in June also, my lord. People coming late, my lord, your lordship has dismissed petitions, my lord. If I can persuade your lordship, my lord, with those orders.
But he has accepted the rule. He has accepted the rule, and thereafter he appeared in the examination.
I'm aggrieved by the rules.
No.
Well,
Yeah, without having any demur, he appeared in the examination. Now he is coming. He is taking a chance.
How many marks did you score in the?
My lord, kindly see the rules. It says on the basis of 2 marks for each year of service.
Yes. Where is this each year? This I cannot find.
My lord, each my lord will be calculated from A to D. A to D.
That is not each year.
My lord, A to 3rd April to
I'll post this
31st
later
March
on.
2020.
Doesn't matter. I'll post this later on. Come. Whether the petitioner would be entitled to marks on account of prior teaching experience in 2nd SLST 80 2025 is to be decided. Stop. These matters are fixed when?
22nd of December.
Released on 22nd December.
But item number 55. 55, my lord. Those are permanent posts in private.
All right. As and when the matters are taken up, orders will be
But
passed.
let that also be taken up on that. Because the point will be decided.
13.
Judgment है ना चुप.
Same over here, prior teaching experience.
Contractual teacher, part-time contractual teacher.
Where is the petitioner? Yes.
The commission was supposed to revert back with instructions. That part-time teacher in a government-sponsored school. That we have affirmed a supplementary affidavit from where we can also demonstrate that at least one of us was appointed as an examiner by the board even to examine Madhyamik answer scripts. Apart from that, my lord, we have enclosed
How many days did you teach?
From the year 2013. 2020 लिखे थे 2020 अरे এটা তো সেদিনকে সার্টিফিকেট ইস্যু করছে অ্যাপয়েন্টমেন্ট লেটার ওটা ইয়ারলি
Come ready. 20 seconds. Come ready. 20 seconds. Don't record an order. List নিচে 20 seconds. List নিচে 20 seconds লিখে দেবেন.
ফাইল দাও. ফাইলটা দাও. My lord, part-time teacher claiming 10 marks, my lord, your lordship can hear.
20 seconds? All right, 20 seconds. 1 year total completed, 1 year.
It's a government sponsored part-time teacher, continuous service. They are saying part-time teacher, not substantive, they will not get.
No, but then is the service continuous?
Yes, service continuous.
In this matter, Gaurav was appearing for the state.
I am not passing any order today.
15 months. 15 take a twice.
None appears on behalf of the petitioner at the time of call. Released on 5th January. Yes. 16, same order. 17 also same order. All right. 18 also same order. 19 also same order. 20 same. 21 same.
15.
8.
For 22.
22 same না এখানে জয়েন করছি দেরি করে এক্সপেরিয়েন্স
Which item number is called?
Anamika Roy.
My lord, 15 to 23. I'm praying for short Passover. I'm late by 21, 22 ka amra. 21, 15 to 21.
I am posting it on the 5th of January.
5th of January.
And I'm recording nobody was present.
I'm praying for short Passover. I'm led by MD Sarwar Jahan. He is engaged in court number.
Order record করতে হবে না 5th January থাকুক.
5th January.
22nd এটা 21 পর্যন্ত হলো.
My lord, 23 to 26 same.
As and when it is called on, just wait.
My lord, I'm for the petitioner.
22?
Yes, my lord.
Yes.
My lord, the petitioner has been appointed in a delay period due to the fault of the respondent authorities because someone else has been given appointment in the place of the petitioner. So that is why, my lord, she is praying for the full marks of prior teaching experience, as it is the respondent authority's fault and not any fault of or her own part. So in support of that, I have 2015-14 SSC 335.
Says rejected, mirror.
$15, 22 is going on.
Yes. Kindly see the paragraph 14.
Which one? Which judgment?
2015-14 SCC 335.
Paragraph
14.
All right.
May I place before your lordship?
But this is in respect of promotion.
My lord, but this can be interpreted in case of this petitioner, my lord.
Yes.
In normal circumstances, when retrospective promotions is affected, all benefits flowing therefrom, including monetary benefits, must be extended to an employee who has been denied promotion ultimately. What is the monetary benefits? So and so. In state of Kerala versus E.K. Vaskaran Pillai, this court held that principle of no work, no pay cannot be accepted as a rule of thumb, and the matter will have to be considered on a case-to-case basis. My lord, paragraph 14 also, paragraph 15 also, my lord. We are conscious that even in the absence of statutory provision, normal rule is no work, no pay. In appropriate cases, a court of law may take into account all the facts in the entirety and pass an appropriate order in consonance with law. The principle of no work, no pay would not be attracted where the respondents were in fault in not considering the case of the appellant.
So if you have a case for payment, then that is different. What about experience?
My lord, here it says that full benefits, including monetary benefits.
Monetary benefits you can get.
Other
How
benefits.
can you get the experience without teaching?
My lord, other benefits as well. Kindly see the second order, that is the judgment passed by Honorable Division Bench of this court, and which where it has been considered the Supreme Court judgment. Paragraph 9. On the other hand, the counsel for the state submits that there are other judgments which run counter to this proposition for the simple reason that the person who had not worked, not discharged the duties attached to this post, not entitled to receive any amount or
Don't go by the amount.
Or otherwise, my lord. Amount or otherwise means other.
It may be promotion.
My lord,
it may be granting notional benefits. There are various.
The fact remains same that no work. There has been no work rendered, no duties has been rendered. The fact remains same. And in the petitioner's case also the fact is same that she had not been able to render her duties due to the respondent's fault, my lord.
I am still not convinced.
My lord, the judgments have been so far saying that even if on the part of there has been no work has been rendered, no duties have been rendered, then also if the respondents are at fault.
Would you like to do some more research, or I'll pass order today?
Then, my lord, kindly give me some more time.
Some more time? All right. The petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Ramesh Kumar, the Union of India and others, reported in 2015, 14 SCC 335, and the order passed by the Honorable Division Bench of this court on 25th February 2025 in FMA 1235 of 2024 with IA number CAN 1 of 2024. In support of the submission that the petitioner ought to be given the benefit of prior teaching experience, as the petitioner was no way responsible for the delay in her appointment. Stop. Paragraph. The court is not convinced with the submission made by the petitioner. Stop. To allow the learned advocate for the petitioner to come ready with further research work, released on 22nd December.
Grateful, my lord.
I have passed a judgment just a few days back.
I am aware of that, but that is, my lord, no work, no experience. That judgment is of 1996, my lord.
It is a very recent judgment which has been taken into consideration, where it is specifically mentioned for notional benefits, for promotion and everything, you can get that. But without working, you cannot get experience. This is exactly the phrase that has been used. All right?
And I will do some more.
Please.
Thank you. Grateful, my lord.
23, 24, 25, 26. My lord, in 20. I'm not recording an order. ওগুলো কি রেকর্ড করা হয়েছে লিস্ট বলে কিছু হয়নি তো 15 থেকে 21 no order recorded. It will come in the monthly list of January.
272564
My lord, in item 22, my lord, affidavit of service kindly taken.
Yes, give. 22 affidavit of service written with the records.
Grateful, my lord.
27, my lord, I appear for the petitioner, my lord. Here, my lord, the petitioner participated in the second SLST, my lord. My petitioner is possessing, my lord, EWS certificate, my lord. But pursuant to the notification which was issued on 22nd September, my lord, I could not upload the same, my lord. But although, my lord, the
When did you
certificate,
obtain the
my
certificate?
23rd September.
You obtained it on 23rd September. How will you get the benefit of that?
But on 23rd September, my lord, since, my lord, the opportunity was granted by notification dated 22nd September, notification was issued to upload the certificate to update the EWS, my lord, the category, my lord.
What does updating mean?
But to get the benefit of the EWS
Yes.
certificate, my lord.
According to the rules, you are required to possess the certificate prior to the last date of closing the application.
Yes,
Application closed in July. You got it in September. Why will the benefit be granted to you?
Since, my lord, prior to that there was no notification, my lord.
Which notification?
To update, my lord, the same, my lord. And I have
The
obtained
application, suppose that window had not been given, what would have happened? Nothing.
Yes.
So, dismissed. Please come. The petitioner participated in the recruitment process of assistant teachers conducted by the West Bengal Central School Service Commission in the year 2025. She participated. She seeks reservation under the EWS category. Stop. The certificate relied upon by the petitioner,
page 45,
in support of such reservation was issued on 23rd of September 2025. The last date of submitting the application was 21st July 2025. The petitioner did not possess any certificate on that date. Stop. The recruitment notice clearly mentioned that for being considered in the reserved category, certificates issued by the competent authorities of only the government of West Bengal on or before the last date of receiving the online applications shall be treated as valid. Step. Admittedly, on the day of admittedly, the petitioner failed to procure the EWS certificate on or before the last date of receiving the online application. Step. The petitioner relies on the notice, addendum notice, published by the Commission on 30th July 2025 in support of the second of 5th August 25 and 22nd September 2025 in support of the submission that the Commission granted last opportunity to the candidates to update their categories, and accordingly the Commission ought to take into consideration the EWS certificate relied upon by the petitioner issued on 23rd September 2025. Stop. The court is not convinced with the submission made by the petitioner? Stop. The recruitment notice relying on which the applications were called for mentioned a particular date within which the certificate obtained by the candidate for seeking reservation. Stop. Permitting a candidate to update or edit the caste category or their category for reservation does not imply that certificates issued beyond the prescribed period can be relied upon. Stop. Next. If such relief is extended to the petitioner, then several other candidates who received their certificate after the last date will be deprived of the opportunity to be treated as reserved category candidate. Stop. The same will amount to discrimination and injustice caused to them. Stop. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Get through. But 28, my lord, I am for the petition, my lord. On the last occasion, my lord was pleased to direct the commission an instruction, my lord. Here, my lord, the petitioner, my lord, that did not mark the appropriate option in the OMR sheet against the category, my lord, booklet series. Although the petitioner mentioned the corresponding series at the designated space in the OMR, as a result of which our OMR were not assessed. Whereas, my lord, I have relied upon a document of some candidates who also made mistakes in filling up the OMR. Their candidature were considered and marks have been awarded. Considering the same, my lord was pleased to take the commission to obtain instruction.
Yes. My lord, kindly see first that his booklet, that's page 28. That's a OMR.
Yes.
Well, that is the round sign has not been given there. That is only the S booklet series. Right. Well, now your lordships will find the documents which he has given. Well, 20, 32, 30 your lordships will find. This another one, he has also not given. 32 also not given. Now, let kindly this supplementary affidavit which has been filed. That's page 6.
Hey, supplementary copy dada ke dicho?
His allegation is that some persons have not given that marks. It's a round marks, round sign. But your lordships will find from that the roll number has been given.
I did not follow. Page 6, what you showed? Supplementary?
He roll in the roll number.
Yes.
But they committed, according to him, they committed mistake by bubbling it. But a roll number has been given. Therefore, we can reconcile this from the roll number. Then they will have similarly venue code. Venue code can be reconciled. And subject code has also been given. Booklet has been given. Now, other, apart from booklet, the things, my lord, one can reconcile. Our case, our motto is not to reject everyone. If I can reconcile, I can reconcile. That the here booklet is given there. Booklet, if it is not there, then it cannot be reconciled.
The booklet is mentioned in page 28.
No, page 28, if I do it, then I have to tamper his booklet. That I cannot do it.
I did not follow. Why tamper?
But if I make a bubble there,
No, why will you make a bubble? You will not make. The booklet series is there. But then possibly commission is
booklet
right.
series is there.
I think the commission is right.
My lord, kindly appreciate. Kindly see, my lord, supplementary fee page 6, my lord.
Yes.
My lord, the roll number, my lord. But the roll number of the OMR, my lord, is separated into separate blocks. Separate blocks. Each block consists of one digit. My lord, the candidate is required to mention the particular, my lord, the digit at the designated space at the top of the block, my lord, and they are required to, my lord, mark the corresponding, my lord, the circle just below it. Here, my lord, kindly see, my lord, against the 9th block, my lord, digit 2, my lord, they have marked, the candidate has marked against the circle with 1, not 2, my lord. 9th block, my lord, 2, 2, 1, 2, 5, 7, 6, 1, 2 is 2, my lord. Against that, my lord, the candidate has marked, my lord, the circle with, my lord, 1, not, my lord, the circle with numerical 2. Despite that, my lord, the OMR has been, my lord, the assessed and marked has been awarded.
They say that it could not have been done. You know the reason why? What does OMR mean? It's optical marking, right? Till you bubble it, the computer or the machine will not record anything.
But
you have not bubbled anything. You're writing, the computer cannot see. The computer will only see the bubbling part, the shading.
Yes,
where the shading is not there.
But I have also annexed, my lord, page 8, my lord, of the supplementary affidavit, my lord. That can also, my lord,
bubbling is not there.
Not there, my lord. 84.
Yes, and they have
assessed, marked, and assessed. OMR has been assessed and marked has been out.
84, page 8 of the supplementary. Please check.
But that is a subject code. Can you see?
Yes.
That subject code also can be reconciled.
Apart from the booklet series, everything can be reconciled.
Yes, because
how is it so?
One is roll number is there. What is this? Venue is there, and
no, venue is not important. Thing is,
roll number is important.
Yes, the roll number is important. The petitioner's roll number is there. It is only the booklet series which has not been bubbled. And the subject code in page 8 has not been bubbled in the supplementary. You could find out which subject code the candidate mentioned.
But from the roll number, we can ascertain the subject code. But from the roll number, it is correct. Then the accepting booklet, others code can be ascertained.
Anyway, I am not inclined. Please come. The petitioner, how many are there? Petitioners participated in the recruitment process for appointment as assistant teachers. Assistant teachers conducted by the West Bengal Central School Service Commission in SLST 2. They are aggrieved as their OMR answer.
Untainted teacher, my lord.
What can the court do? How can this mistake be done? Try to understand.
Let them consider, my lord, only.
How will they consider? Is there any scope for consideration? Where is Mr. Bandyopadhyay? Is there any scope for consideration? They say they are untainted teachers.
Mr. Bhattacharya is there.
No scope. I do not know. See,
If we mark the
at least judicially, I cannot. If they do it on their own, that is up to them. I won't stand in the way.
Your Lordship's order passed on 18th of November in WP 25765.
There was no document, my lord.
That also, there is an order that without this circling and everything.
Yes, I do not know. But then it is up to you whether you can consider or not. Judicially, I cannot pass order.
Instructions, no.
Then OMR mismatch will be
They
there.
are aggrieved as their OMR answer sheet has not been assessed, as they inadvertently failed to shade their booklet series. Stop. A supplementary affidavit has been filed by the petitioners in support of the submission that, in respect of candidates who did not shade the subject code and erroneously shaded their roll number, দিয়ে শুরু করলাম। Their answer scripts have been assessed. Stop. Prayer has been made to direct the commission to assess their OMR answer sheet relying on the booklet series marked by them. Okay, answer sheet alphabetically marked by them. Stop. Paragraph. Learned senior counsel representing the commission submits that that as the roll number of the candidate who erroneously bubbled the space meant for roll number and the subject code হচ্ছে না, বলুন আর একবার। ঠিক আছে, can be reconciled accordingly. The OMR sheets of the said candidates have been assessed. Stop. Booklet series is different in respect of each candidate, and the candidate was mandatorily required to shade the booklet series. Stop. By merely mentioning the booklet series alphabetically will not be enough for assessment of the OMR answer sheet. Stop. Paragraph. I have heard the submission made on behalf of both the parties. Stop. The OMR answer sheet of the petitioners is annexed to the writ petition. The instruction mentioned in bold letters at the top of the OMR sheet clearly lay down that items in serial numbers 1 to 5 should be properly filled and shaded in appropriate boxes and circles, otherwise the OMR sheet cannot be evaluated and shall be treated as cancelled. Evaluated or, not and. The said instruction is mentioned in English language and vernacular. Stop. The candidate, for reasons best known, though mentioned the booklet series in alphabet, but failed to shade the proper circle. Stop. As the booklet series differs from candidate to candidate, accordingly, the commission cannot be directed to reconsider assessment of the answer sheet. Stop. The petitioner at the time of filling up the OMR answer sheet. Stop. The court does not find any error on the part of the commission in not assessing the answer sheet of the petitioners. Stop. In view of the above, no relief can be granted to the petitioners in the instant case. The writ petition fails and is hereby dismissed.
Get one.
Please issue the petition. Kindly
My lord, in this matter, I have just now received the report. I have not gone through just 2 minutes back. Can I take it, my lord, next week, my lord, Tuesday? This is the evaluation.
But I have just, my lord, one request to your lordships, my lord, subject to, my lord, sanction from my learned seniors here. My lord, now, my lord, we are in the process of, my lord, the verification of the documents. If I just could, my lord, because here, my lord, lordship kindly remembers this incumbent, my lord, had specifically, my lord, made the objection during the time when she was supposed to make the objection of the answer scripts and the questions. So even in spite of that, my lord, that was not taken care of. Lord, may I pray before your lordships till the next date of hearing, my lord, if this candidature of this incumbent, my lord, is subject to the result of this writ petition, because this may happen that I may be, because I am anyways, my lord, through. But it may happen.
Tomorrow I will just read it and I will place my submission. Can I take it tomorrow?
Not today.
Grateful. And may I just get a copy of this, because lordship's earlier direction, my lord, is directed upon the commission, my lord, so that they circulate the copy on me as well.
Give a copy. At least if the hard copy is not there, a soft copy.
I am sending it to a soft copy
yes.
to my junior. They will hand it over.
Yes,
Just now it has come to me.
Grateful, man.
Item 30 also not identical issue, my lord.
Which identical?
29.
Item 30.
They are supposed to file a report, my lord.
Ritu Chakraborty.
Not Ritu Chakraborty. 30.
আমরা তো ঋতু চক্রবর্তী করলাম
29.
Item 30.
Lord, I have to check up. I have to check up. Kindly give me to this time.
Not today.
The report has not yet come. Report has not yet reached.
Get it ready and bring it tomorrow, and soft copy be served upon the petitioner.
Give me 1 second. Just give me 1 second. Take it tomorrow. Possibly he is right. Take it tomorrow.
All right, tomorrow.
For the petitioner, my lord, there is a question model answer mismatch. There was a direction to file report. I have not yet received the report. It's regarding the subject Sanskrit. I have not received the report yet.
Will this be taken up tomorrow or today?
Tomorrow. I will give the report.
Very well. May I get a copy?
Yes.
Mr. Bhattacharya, I am sending you the soft copy. You just send it send it to him.
Very
well. Very well.
Soft copy, kindly take it.
Yes.
So not today.
পরের টা আমাদের 34 বোধহয় কপি দিয়ে দিলাম 30 কত রাখলে 32
My lord, Mr. Anindo Bose is another court is saying yes, my lord. Kindly.
Who is he appearing for?
Anindo Bose.
Who is he appearing for?
I am for petitioner. We are for petitioner.
Are you sure he is appearing?
He is appearing.
What is the name of the petitioner?
Hey.
32.
I don't see his name. Somebody else's name is there. There is here also a written report is to be disclosed. Come tomorrow. They'll prepare a report and it will be circulated. $33.
I'm for the petitioner, my lord, led by Mr. Firdaus Samim. He is engaged into courtroom number 14, my lord. For that reason, I'm praying for a not today.
Not today?
Yes.
Not today.
Lord, I'm for the petitioner. This is the report is due. This report, the model answer question due. I have not yet received the report. That is only I have only one humble submission, my lord. Due to inadvertence, my lord, one candidate's preliminary objection has been left out. So I prepared a supplementary affidavit. I already served upon the commission. My lord, can let it be taken into record.
Nutrition subject yesterday your lordship has dismissed it.
No, the question to question different. Question to question, there are 6 questions here. Question to question, it may differ. Their decision may differ. So a report is required to be considered, my lord.
All right, supplementary affidavit filed on behalf of the petitioner number 8 in court today.
Have you got the report?
Yes, I had already.
Mr. Lairi, have you got the report?
No, sir. I have not yet received.
Okay, I'm giving it.
Very well, ma'am. Tomorrow?
A report was directed to be filed by the commission. Let the report be prepared and served upon the learned advocate for the petitioner, released on 22nd.
My lord, tomorrow your lordship is keeping the other matters.
There is no supplementary in those other matters.
No, it is just a document I've already handed over. I'll keep it tomorrow, my lord. It will not change the nature and character of the matter.
If it has to be kept tomorrow, then supplementary, you take it back. I'm not passing any order.
Very well. I'm taking it back. Kindly keep it tomorrow.
Not today.
Yes, very well. Tomorrow I'll sub. Grateful. Tomorrow.
35.
35, no one is there. 35 and 36.
35 and 36?
No one's there.
No one is there. But then you are supposed to take instruction. Commission.
We have taken the instructions. He has not filled up the application form properly.
Do one thing, none for the petitioner. Released on 22nd. 36 is same.
I'm for the petition. I'm challenging the list. Allegedly, and my lord, the court fees has been paid. Lordship may kindly takes up. I'm challenging the list where, my lord, the names of my clients have been published, claiming them to be the tainted candidates. Now, my lord, Lordship may kindly takes up the judgment of the Supreme Court, which I have provided singly, not annexed. On the last occasion, it might be there in your Lordship's records. The
Which judgment?
Boishaki.
Boishaki.
Now, my lord, parts and bits of the judgment are being placed before your Lordship without placing the entirety. I'll be praying that kindly allows me to place the paragraphs, some paragraphs, with the context. First, my lord, only to just, my lord, by this time, my lord, it has, my lord, your Lordship might have, my lord, the entire judgment might have been seen many times. It is by heart by now, but still, kindly sees the internal page 9, paragraph 363, which has been shown many times, but still also I am showing to your Lordship. No, এইখানে না জাজমেন্টটা বের কর বৈশাখে না লাগানো আলাদা করে লাগানো থাকলে একই জিনিস 10 বার করে দেখাতো পেজ 9 ইন্টারনাল পেজ 9 আমি ইন্টারনাল পেজ দেখাচ্ছি OMR sheets available in the 3 hard disks if not already done or such portion not done must be uploaded in the website of SSC forthwith and made available to the public for viewing. These are, my lord, the OMR sheets of the, because your Lordship was not there in the first round of litigation. May I just indicate to your Lordship what were the facts? Because I am there from, my lord, round 1. These are the OMR sheets which have been obtained from a person known as Pankaj Bansal, who was one of the employees of NISA, being the outside agency which was, my lord, engaged for scanning and evaluation of the OMR sheets. This particular gentleman was in Noida. The OMR sheets were Lordship may not look. It was there. May kindly takes, my lord, I'll not tell anything which is not in the facts. He was in Noida. Certain hard disks were recovered from him. And, my lord, a certificate under 65B was taken from him, which was the subject matter of challenge before the Honorable Supreme Court. Now it is subject matter before the trial because Pankaj Bansal has to come and depose and support 65B. If he doesn't come, depose, support 65B, that these hard disks will not be proved. This hard disk, as of today, on record, has not been authenticated by any FSL, any agency. But the Honorable Supreme Court has taken this hard disk into account in view of the fact that this hard disk was discovered during the CBI proceedings and the Commission has not disputed. So therefore, these OMR sheets are being taken into account. And from those OMR sheets, it apparently transferred that the person's marks which have been given were in mismatch with the marks which were there in the SSC server, which was not recovered from there. It was from SSC server. We were given appointment on the basis of SSC server, and these are the marks of the OMR sheets, evaluated OMR sheets. Now, my lord, on the first round of litigation, it was shown to the court only there were several blank OMR sheets. I will show how many blank OMR sheets are there, but the petitioners before your Lordship, I have annexed the OMR sheets, are persons who have filled up the entire OMR sheets. So they are not the blank OMR sheet candidates. That is why it comes to our second paragraph. Persons who have been appointed outside the panel. These are the persons appointed outside the panel these are persons, they did not even participate in the recruitment process. Yesterday, Mr. Shamim was doing one matter where your Lordship has been pleased to direct the board to produce that affidavit which was filed before the Honorable Justice Gangabadhyay, from where the main conflict began. Because at that relevant point of time, that was also taken into account by the Honorable Supreme Court.
The SSC said that we have given appointments to certain persons, but the board came and said that no, we don't have the recommendation letters, but we have given appointment. So these are the persons who are outside the panel persons. After expiry of the panel are also the persons who have been appointed post expiry of the panel, and in these appointments there are heavy criticism from Bar committee in respect of 9 and in respect of Group D and Group C, and my lord, criticism from the CBI and subsequently the finding of the Honorable Supreme Court at paragraph 31, which says that this is illegal, and it is being argued before a lordship that though it is illegal, we are not tainted. But I'll try to substantiate that also. And also those who submitted blank OMRs. How many blank OMRs were submitted? I will show from the CBI's record. That will also show that these are the numbers of blank OMRs. So we do not fall in either of these categories. But obtained appointment must return all remuneration and benefits received by them to the state exchequer along with interest calculated at 12% per annum from the such and such answer. Now, my lord, kindly comes to the paragraph where the Honorable Supreme Court has set out the table while recording the submissions of the board. Kindly comes to paragraph 23, internal page 28. Whether this was at all taken into account, accepted by the Honorable Supreme Court, that is subject matter before your lordship interpretation. Paragraph 23, page 28. WBSSC has been candid enough to admit 1. Rank jumping, that is to say, candidates having lower rank were preferred over those having higher rank. These are persons who had participated but rank jumped. Out of panel appointments, these is candidates who are not in the panel of shortlisting candidates have been recommended and appointed. So these are the persons who did not even participate in the recruitment process. 3. Candidates who were not recommended by SSC were appointed by the board. These are also persons who have not participated. Manipulation of OMR scores, however, there is a discrepancy in both the number of candidates and their corresponding percentage where such irregularities have been identified. So there is discrepancy. What are the discrepancies? Now the Supreme Court is trying to, in the judgment, show what are the discrepancies. Impugned judgments refers to the following statistical report submitted by the WBSSC before the High Court. So this was submitted before the Honorable Division Bench. This is not the final one. Here, my lord, lordship would say this only one line, that is OMR issue 783-1741 comes to 2524. Now, in the written submission filed on behalf of the SSC in court, 2 tables have been furnished. Table 1 pertains to candidates who either jump rank or were appointed despite not being in the panel. Their details as under such and such. Now, Mala kindly takes into account for this case, Group D and Group C and D, Table 1, rank jump candidates 132, 237, total is 463. Out of panel but still appointed. Out of panel but still appointed. So rank jump and out of panel combined is 381 and 608. This my lord comes to 989. Kindly, my lord, I have worked out. Table is there. Table 2 furnished by the SSC is for candidates who were appointed by manipulating OMR sheets. Table 2 is under. Now, my lord, number of candidates with alleged OMR score is 592 in respect of 910. 907 in respect of 1112. Group C, Group D 3481, 2823. Now, my lord, this yesterday, your lordship was pleased to direct in one matter for publication of 952. These were the candidates in respect of whom, my lord, there was mismatch, but all of these candidates were not appointed. Kindly see the next column. 808 candidates were appointed. This 952 had already been published in the year 2022. Most probably the date is in November 2022. This was challenged by some of the teachers, saying that we should be added in the party respondent, which was rejected by the Honorable Justice Gangobadhyay. Out of that, first round of appeal went to Honorable, disposed of by the division bench, presided over by Honorable Justice Subrata Talukdar. Thereafter, to Supreme Court, disposed of by the Honorable Justice Onruddha Bose. That is first round. So this was published. Your Worship has yesterday directed republication. 907, this was only the names have been published, not the OMR sheets. Lordship will be taking up several matters subsequently. So therefore, I'm just, though this is, I'm in now appearing Group C, Group D, but still I am giving the backdrop. Why only the names were published? Because when this order was passed by the Honorable Justice Gangobadhyay, as his Lordship then was, some of the 11-12 candidates, because I did the matter, had preferred the application, rejected, went to the division bench. Order was originally passed. I have the orders. If your Lordship wants, I can show. Order was originally passed for publication of the OMR sheets as well as the names, father's name, everything. Though I have a issue with regard to publication of father's name and whether it is at all to be construed as particulars within the meaning, within the my lord word particulars. But my lord, there was a direction. That direction was challenged by us before the Honorable Division Bench, presided over by the Honorable Justice Somen Sen. His Lordship was, the Honorable Division Bench was pleased to direct that since you are similarly circumstanced with the 9-10 candidates, there will be no publication, but one publication in respect of the names were upheld. That was upheld in the Supreme Court also, but the OMR sheets have till date of 11-12 not been published. Now, my lord, Group C, 34812823, and my lord, the Honorable Supreme Court has taken up this number and has not taken up the, now since the Honorable Supreme, everything is closed now, we cannot argue all these things. 7821911 are the persons who were out of panel but appointed. In another written submission, so therefore Supreme Court is recording how there is a discrepancy. These are not the sacrosanct figures. As it is being placed before a Lordship, these are not the sacrosanct figures. These are the process of recording, that this was before the Honorable Division Bench, this is before me, and thereafter the findings. In another written submission filed on behalf of the WB SSC, this in this court, it is claimed that on further verification, the following details of candidates either rank jump or were appointed despite not being in the panel came to light. So therefore, now the figures were again recalculated, and this is the my lord list. Persons identified as tainted in the category of rank jump and out of panel but appointed. Rank jump is such and such. Kindly see now Group C and Group D, 132 and 237 is 369. I have calculated this, and 249 and 371. This is out of panel but still appointed. So rank jump and out of panel. This figure would be 369 plus 620 is 998. 989. Previous page also the same number is there. So these are the ingredients now which has been taken into account for publication of the list which is challenged before a Lordship. My contention of challenge is that the list is not right. It includes persons who are not supposed to be, that is us, who are not supposed to be in the list, excludes persons who are supposed to be in the list, being the expired panel candidates. Now, my lord, this list kindly now takes into account, my lord, the calculation. So if we take 132,237, it comes to 369. 249,371 comes, and thereafter the details of candidates who were appointed by manipulation of OMR sheet is under. Now, my lord, I will only take the OMR issue recommended by candidates. Next B. Number of candidates identified by CBI appointed and not appointed. This includes appointed and not appointed. 3481, which is not been taken into account and has not been published. 782 plus 1741 comes to 2523. If my lord adds 369, 620 and 2523, it comes to 3512, which is the figure of the impugned list. Kindly, if your lordship, would your lordship see or lordship remembers, yes, by now. So, while my lord publishing this list, my lord, the expiry panel has not been taken into account. OMR mismatch has been taken into account, and which in my humble submission is erroneous in view of the findings of the Honorable Supreme Court subsequently, which has been again, my lord, clarified and reiterated by the Honorable Division Bench. That is my point, one of points. WBSSC claim that 57 Group C and 170 Group D, I have annexed the list also, with OMR mismatch were not recommended but appointed. However, their names also figure in the list of candidates appointed through rank jumping and out of panel. So therefore, these candidates would also come under rank jump and out of panel, because these are the candidates who didn't even participate. They were taken in, and what was the mechanism adopted, that also I'll show, to show that these are the real culprits who had come subsequently, did not even participate, and who had taken the advantage of the SSC forming a committee. SSC not forming a committee, state government forming a committee under the guidance of the Joint Secretary of the state government in the month of November. And previously also there was, these things were continuing, because after we are the persons who have been appointed in the first round of this counseling, first and second round. Everything started from third round onwards. Third, fourth, fifth, it went down to sixth round. So therefore, this committee, which has been heavily criticized by the BAC committee, saying that this particular committee, which was formed under the chairmanship of the Joint Secretary of the Government of West Bengal, was not appropriate, as the government cannot regulate the recruitment process. And this committee, the persons who were there in this particular committee, have been, my lord, made accused persons in the criminal proceedings, as, my lord, opined by the Honorable Justice BAC committee. That is also there in a judgment which I'll show to your lordship if your lordship has not come across. Judgment dated 15th May 2022, passed by the Honorable Justice Talukdar and the Honorable Justice Supratim Bhattacharya. Oh, Justice Anandaman. So therefore, there also, because that is the only judgment from where we know what BAC committee has come to, my lord, conclusions. Because as of today, the BAC committee report has not been published. When the state government went to the Honorable Supreme Court and the Honorable Supreme Court, because it was not published there, the Supreme Court was of the view that the judgment itself quotes BAC committee report in extenso, so therefore there is no further use of publication. So that is the only judgment from where your lordship can see what were the findings. At least we can. Your lordship can always call for the record. At least we can see. So that is also, that I'll also place before lordship relevant parts, so that lordship subsequently, my lord, takes up. WBSSC claims, so yes. However, their names also figured in the list of candidates appointed through rank jump and out of panel. WBSSC admits that 1498 is the calculation, addition of this out of panel but still appointed. 1498 out of panel were illegally appointed. This is 1498 is addition of this table A, out of panel but still appointed. It comes to 1498. 126 is the calculation of this 926 candidates. This has been taken, 926. 4091 candidates were recommended despite OMR mismatch. 4091 is the addition which is there in table B itself, 4091. Thus, excluding 239 candidates, 239 candidates is 57 plus 170, that who fall under both OMR mismatch and other irregularities, illegalities. West Bengal such and such acknowledged that 6276 illegal appointments were made. At this stage, so these are the submissions which have been recorded by the Honorable Supreme Court. At this stage, we would like to refer to the affidavit dated such and such filed on behalf of the Commission before the High Court at Calcutta, where SSC stated, I will not place the entire, but it was stated that relevant parties, which has, my lord, weighed. However, as the CBI has not disclosed the details with regard to the said illegal appointments detected by them to the chairman or to the secretary of the commission is not in a position to state the number of such illegal recommendations and stroke or furnish the details of such candidates. So therefore, the commission took the stand before the Honorable Supreme Court that we don't have any definite data. So that is the reason the Honorable Supreme Court was of the view that then the entire selections should go. Because if this is the stand of the commission that CBI has not given to me, I cannot disclose. This was the last stand. WBSSC, however, submits that the affidavit dated 27/9/2022 was filed before they had access to the status reports of the CBI and the data details gathered pursuant to their investigation, including the scanned mirror copies of the OMR sheets. The data which has now come to light shows segregation of meritorious candidates from those appointed illegally. Therefore, SSC argues that the entire selection process should not be annulled. So this was the submissions. Till here are the submissions. Now, paragraph 28. We may have accepted this argument if SSC had original physical OMR sheets or mirror copies of the OMR sheets. So therefore, the Honorable Supreme Court did not take into account whatever that these calculations were given. But one of my point contention is that even as of today, the SSC is proceeding on basis as if these data were sacrosanct. These data are not sacrosanct. That is my point that I'm trying to substantiate. However, WBSSC accepts that they do not have any physical OMR sheets as they were destroyed in terms of Rule 21 of the classes 11-12, which required, which the rule is quoted. This was the stand. Admittedly, the OMR sheets for the candidates who had applied for non-teaching Group C/D were also destroyed. The reliance placed on Rule 21 of the Commission to justify the destruction of OMR sheet is misimpressed, as Rule 21 applies to assistant teachers of 9, 10, 11, 12, not to non-teaching Group C, Group D staffs, because Rule 21 was there in 2016 rules. Group D, Group C, Group D were being proceeded on the basis of 2009 rules. In 2009 rules, there was no provision for destruction of OMR sheets. In 2021 rules, 2016 rule, Rule 21 was there. The Commission had adopted a policy decision on the analogy of the Rule 21. They had destroyed the OMR sheets of Group D, Group C too. That was not accepted by the Honorable Supreme Court, saying that there was no provision. And another difference on provision is that in teachers, there was no provision for extension of panel, life of panel. In Group C, Group D, there was a provision for extension of panel, but it has to be by way of a written order showing reasons. In the entire 11,000 pages before the Honorable Supreme Court, the compilation, there was nothing, no document to show that in fact Group D, Group C panels were although they were proceeding with the counseling, but there was no order showing. I'll show that rule also. There was no order saying the reasons as to why it is expedient for the Commission to extend the period of life of the panel. As Rule 21 applies to such as it is acknowledged that the chairman of the Commission in the letter dated such and instructed destruction of the OMR sheets relating to 2016 selection process for assistant teachers, Group D, Group C. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. it is apparent that the time period fixed in Rule 21 was coinciding with the time period specified for validity of the panel. Further, the Commission did not maintain mirror copies of the OMR sheets in their records. Thus, the destruction of the physical OMR sheets and the failure to maintain mirror images of OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. So, destruction but continuation without any extension. On the basis of this, paragraph 31 comes, which has been placed, I know, innumerable times, but I have taken this opportunity to place it in continuity. The Commission has also tried to justify the extension of the term of the panel. As noted above, the time period of 1 year specified in Rule 21 for destruction of the OMR sheet coincides with the time period specified for validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teachers 9, 10, 11, 12 were made after expiry of panel. This is illegal and contrary to the rules. So why the Supreme Court has taken the pain to say in respect of 9, 10? Because there was no BAC committee. BAC committee was only for Group C and Group D. And 9, 10, because at that relevant point of time, Lokhi Tunda was the first matter. Second matter was Sabina Yasmin. No, Shetapuddin is 9, 10. So at that Lokhi Tunda was the first matter where Group D appointments were cancelled by the Honorable Justice Gangobadhyay. Thereafter came the 9, 10. Thereafter Group C. Thereafter last 11, 12. So therefore, the Supreme Court took up, my lord, the pains to, my lord, say that this is illegal and contrary to the rules. Reliance on the orders judgments of the High Court in stray cases of rank jumping where the High Court directed to appoint candidates after expiry of the validity of panel would not have any significant impact because these persons were also there before the Honorable Supreme Court, the expiry panel candidates. They tried to substantiate their appointments saying that, look, we have been appointed pursuant to the orders passed by the Honorable Court. The Honorable Justice Gangobadhyay had also passed many others. Division bench had passed, saying that, look, there is a COVID situation and all these things. But those orders were taken care of by this line, saying that the court at that stage was not concerned and aware of the illegalities in the appointment procedure and had not specifically examined the question of appointment after expiry of panel. So full stop. So nothing after this. All subsequent orders, everything taken care of, and the Honorable Supreme Court holds that this is illegal. Now with regard to why these persons, these names of expiry panel is not being published as tainted. There is also a division bench judgment. It is being sought to be distinguished before a lordship that illegality and tainted are not, my lord, similar things. In my humble submission, there is nothing remains where Honorable Supreme Court has said it is tainted, and because of these proceedings, because I'll show the BAC committee also before a lordship, the the judgment passed by the Honorable Division Bench, presided over by Honorable Justice Subrata Talukdar, that what were the illegalities committed, how it was committed, it is there in the BAC committee report. So therefore, there cannot be anything which can be, my lord, tried to substantiate that these persons are not tainted persons and their names will not be included in the list of the tainted candidates. This argument was also made by me when I was challenging the list of purported tainted candidates in respect of 9, 10, 11, 12. Now, this was moved by me before the Honorable Justice, previous, I'll not take all names, before the coordinate bench, where the coordinate bench was of the view first, saying that why you have not come up after the 17th April order. Because 17th April order said that only the untainted teachers will continue. First question put to me was that why this delay? Why you have come up after the publication of the list? And that was the point which was taken by the Honorable single judge to dismiss And second point which was there was that the Honorable Supreme Court at that relevant point of time was in session of this matter. So these were the 2 points. It was taken up by the Honorable Division Bench. The Honorable Division Bench was of the view that since the Supreme Court is in session of the matter, so therefore this cannot be decided. Obviously, some SLPs were carried up, and those were dismissed. So therefore, by saying this, I'm trying to distinguish the situation which prevailed when I had challenged the, my lord, teachers list, and the situation which is now, as the Honorable Supreme Court has, my lord, passed an order in Paria, Vivek Paria, saying that everything will be scrutinized by the Honorable Single Judge. So therefore, I am now before your lordship with regard to, because obviously the commission will come up and say that the same arguments were made, and in respect of the teachers panel, it is recorded. I have annexed those judgment also. It was recorded, specifically paragraph 31, that my contention was that expiry panel should be included, sorry, other way around. So these will not be relevant as of today, in view of the fact that now everything is being determined and decided by the Honorable your lordships. So now, my lord, now kindly comes to the celebrated paragraphs. Paragraph 45, 46, 47. Lordship may not trouble, my lord. By now, again, it is by heart. The last question, which relates to relief and whether it requires any modification, we find no valid ground or reason to interfere with the direction of the High Court that the service of the tainted candidates were appointed must be terminated, and they should be required to refund any salary stroke payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Which direction? 663, subparagraph 4. So, the Honorable Supreme Court in this has treated 663 subparagraph 4, those 3 categories to be tainted candidates. This is my contention. Now, this has now again been reiterated by the Honorable Division Bench. Not, my lord. Paragraph 6 is for the not specifically found to be tainted. My contention is that I fall in this category, paragraph 46. For candidates not specifically found to be tainted, because in paragraph 363, 4, OMR mismatch is not there. Only the OMR blank OMRs are. And how many blank OMRs, that also I'll show. For the candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violations and irregularities which violates Article 1416. As such, the appointments of these candidates are cancelled. However, candidates who are already employed must not be asked to refund or rescind any payment made to them. However, their services will be terminated. Further, no candidate can be appointed once their intent examination process is declared void. Now, my lord, while referring to this, again paragraph 363 comes, persons who have been directed to refund the salaries. Now kindly comes to division bench.
Page number 167. Volume 2.
Yes. Kindly takes up volume 2, the thinner volume. In the file it is there. Thinner, next, yes, that is the volume. The judgment starts from valid coordinate bencher.
Sanjay Doloi.
Sanjay Kumar Doloi. This has also been placed. I am placing paragraph 31, 32, 167. Yes. Paragraph 31, I am not, my lord, reiterating because this is quote unquote of paragraph 363. Paragraph 32, paragraph 363(4) has classified 3 categories of candidates who can be described as tainted candidates. This is the classification done by the division bench. In Supreme Court, it is there. Interpretation is there by the division bench. This interpretation is not there any elsewhere. Persons who have been tainted outside panel, persons tainted after expiry of panel, and persons who have submitted blank OMR should to obtain appointments. We do not fall within this category, so therefore we are not tainted. Now, I'll be showing your lordship's I'll be drawing your lordship's attention to the CBI affidavit. My lord, may I come back after the lunch recess?
Yes.
Well, because
No, today is Thursday, application day, so it cannot be taken up. After recess, it cannot be done. Tomorrow will be difficult. I'll place it thereafter.
tomorrow is because one of the points that I'll be placing before your lordship, I'll be praying in respect of teachers' matters. Your lordship has been pleased to direct the production of list of persons who have been appointed after expiry of pen. I'll be praying the same in respect of non-teaching staff, group C and D. I'll be trying to substantiate to your lordship the time, because in the Supreme Court, in the compilation, they have disclosed the dates of the my lord counseling. Just a minute. Supreme Court 11,000 পাতার কম্পাইলেশনটা রাহুলের কাছে আছে। এসএসসি মেইনটা কোথায় গেল? আছে সবই আছে। Yes, primary SSC. Yes. Just a minute, madam.
Commission, tell me one thing. The disclaimer that you all have published, is it only in respect of the teachers?
The selection which is going on, second
Yes, I have.
Non-teaching is coming in.
Non-teaching.
Is
going on. Put up a disclaimer also. Maybe, you never know how long.
12th is the last date for filling up the application, tomorrow.
The application stage.
Yes, whether they will be entitled to fill up.
No. Not. In the notification itself, I have annexed the notification. They have said
you cannot.
I cannot. That is my challenge, because this is for the first time I have come to know that my names have been construed to be tainted.
No, but then this panel was there long back.
No, that is my contention. This is for the first time. We have come to know that after Supreme Court order, we are being construed as tainted candidates. After publication, lordship kindly comes to the notification once.
That order may be passed tomorrow, because I'll have.
Page 173.
Kindly seize page.
Volume 2, page 173.
I cannot appear. That is volume 1, page 173. Because why I have said about the teachers is that teachers knew that they might not be, my lord. I'll just place, lordship may not open, page 173. This is the notification dated 9th October 2025, where it has been said, it is clarified that candidates who have been identified as tainted in terms of the judgment dated such and such will not be eligible to apply. And thereafter, my lord, on the same day, the impugned list has been published. So therefore, I cannot. So the interim order that I have prayed before the Honorable Court is that we should be allowed to participate, subject to whatever outcome. If we do not, if we are losing in this writ petition, our candidature will be cancelled. But if this we lose this 12th,
if interim order is passed in your favor, then this is going to create havoc.
This 3512 candidates will be able to appear.
Just see the volume of candidates who will slip in if the permission is granted to you to appear.
Subject, if your lordship is of the view that it is not there.
Interim order cannot be given.
Second interim order that I'll be praying is that for production of the names of the persons who have been my lord, appointed post expiry of the panel in respect of Group C, Group D, and the dates are, Lordship, this is the my lord, the document which was there in the Honorable Supreme Court.
Doesn't matter. I will not take soft copies. Whatever is there.
So they should produce in respect, as your Lordship has directed. The Lordship is considering expiry panel in respect of teachers on the same my lord thing on 6th. Let these also be placed on 6th, as Mr. Dhar will also get the chance to my lord say, because if my argument,
Because he is arguing in the
teachers matters, he is not arguing, but the principle is the same. So principle is the same. So he might have something to say with regard to my submissions also. So everyone, it will be basically not that I'm trying to take a march and of his absence. So that is why I'm saying on 6th, the names of the teachers who have been appointed after my lord, expiry of the panel is there. I don't know whether the third counseling name has been given. Rahul will be, Mr. Singh will be able to say, or Mr. Bandyopadhyay, he's also there.
Yes, after third counseling.
After third counseling, because third counseling was within the validity that they are saying, but the counseling had taken place after the expiry of the panel. The notice was within the validity. The notice was, just a minute.
You say that the notice was published within the validity period, but the counseling actually took
Yes,
place
yes,
after it.
yes. That is the notice. That is the notice. I have taken the note. Just a minute. Publication is on in respect of no, it Group D, Group C. Publication of 11-12 was on 27/11/2017, and in respect of 9-10 it was in March 2018, 12th March 2018. The third counseling notice was published on 8th March 2019. So just one day.
After.
Oh, no, before. 8, 9, 10, 11, 12. 4 days before. And the counseling took place on 19/3/2019, 23/2019. In respect of 11-12 and 9-10 would be 26th, 27th, 28th, 29th March and 1st April 2019. Dates are there if your Lordship wants. Well, what I'm contemplating is that out of this, my lord, the juniors will take the responsibility, not him also, and my juniors, if your Lordship directs, compilation of just the relevant documents with regard to the counseling places, the notices of counseling, the dates of counseling, so that Lordship doesn't have to go through these voluminous things. This difficult.
You can always prepare. Where is the difficulty?
I'll then just the counseling notice. But in respect of Group C, Group D, the counseling notices are not there. There were no counseling notices. Only the dates would be appearing from the compilation which they had filed in the Honorable
How did the candidate get to know?
I think they were intimated via, my lord, SMSs and emails, because the SMSs and emails were there in the application form itself. This is auto-generated now. As we book a gas, it comes, SMSs comes. I think there was some kind of.
So there was no independent communication. No independent communication to the candidate.
I have not come across. I may subject to correction of the commission. My lord, I will. If that has come to, my lord, if that is the query, if that has come to the query, my lord, I will again go through the entire documents and come up. But today, my lord, I would be praying this to interim order. First interim order, Lordship has, my lord.
It cannot be granted.
Second, if your Lordship now can.
Lordship is not heard.
No.
Your Lordship would kindly, bear in mind, if your Lordship is proposing to pass any order,
the first interim order that has been
participation and everything.
No.
Abide by also, my lord.
No, this cannot be done. The second,
then Lordship may kindly
put it up in a cover as you've done in the teaching staff matter. Non-teaching will same thing.
Pass, because this issue is perhaps covered. What he is seeking to raise is perhaps covered, we have some submissions, may the matter be heard tomorrow. I'll, make submissions and thereafter your lordship will pass that.
Did you publish that list?
No. We have not, done anything, without your lord today.
No, this is the query of the court. Then this is what the petitioner is praying.
If I've correctly understood
Candidates.
your lordship wants whether any rider or whether anything has been published in the website.
No. That is the disclaimer. I'm not telling about that. Right now, what the petitioner is saying is the candidates appointed after the expiry of the panel in the teaching staff matter you have produced before the court. Yesterday. This you can do it here. This you can do.
No, I'll come back. Kindly do not pass the order today. Kindly
If
not allow
your lordship is not allowing us to participate, they are
tomorrow.
দাঁড়াও না বলছি তো তুমি সবসময় ভাবো if your lordship is not allowing us to participate, lordship may hear them and pass because this সবসময় ভাবো জানো
Submission, heard submission made on behalf of the petitioners whose name appears.
One. If your lordship is not inclined to grant us, then no orders may be passed. Express rejection is not required.
I'm not rejecting.
Yes.
Acha.
She's
posting because this should be on record.
Yes.
Whose names appears in the list of tainted candidates published by the commission. So, as the name of the petitioners are enlisted in the list of tainted candidates,
allegedly
they cannot participate in the recruitment process of non-teaching staff within bracket clerk and group D.
Allegedly.
In terms of the notification dated 9th October 2025 published by the commission. Stop. The petitioners are aggrieved by the publication of their name in the list of tainted candidates. Stop. Specific submission is that the petitioners cannot be treated as tainted ones. Stop. The issue has to be decided. Stop. List the matter for further consideration on 7th January 2026.
Others matters are in 6th, I think.
If all comes on the same day, it will
And
be difficult.
production of the list.
And it is sure that within one day it cannot be over, right?
No,
the
nothing.
respondents
Process
have
is
not
going.
even started their submission, so it is going to take time. So this
And
is-
production of the list, that
production, let it remain, because since you all are not being allowed to
Instructions
participate.
will not, of course, on instructions.
lordship if kindly records one line. If subsequently if I'm not there,
My
the orders will be there.
I cannot.
Lordship will be deciding the production issue on the next date. Kindly records one.
All right. Prayer has been made to direct the commission to publish the list
Production.
of candidates.
Production.
The production couldn't publish now. Production of the list of candidates in the group C and D category.
এই যে এইটা
Who
দিয়েছে
were
এই দেখো এইটা দিয়েছে
to appear for counseling and appointed after the expiry of the
My
panel.
instruction is, no one was appointed in group C and group D after expiry of time.
All right.
Oh.
Is on instruction.
All right. ঠিক আছে?
Very sure.
The issue will be considered on the next day.
Right.
Deep